Okay, depending on the matter, but let's just deal with criminal matters. I would like to spend, typically I spend between about 5 and 7 hours with the client. And I spread that out over several weeks. The reason for that being that, and it's featured in the DSM-4, that when you're dealing with personality disorders, for instance, they often don't emerge in the first or second session. But as you get to know the personality better, you begin to see the signs of the personality disorder emerging. So the span of time becomes important. In addition to that, I would also do collaterals. Now, collaterals are people who know the person I'm assessing and who can give an opinion about their development or their personality functioning or any issues that built up to the crime that was committed by this individual. So collateral is extremely important.
Like family and friends?
Be families, friends, work colleagues, people who know the person and know the person relatively well. And that's where you begin to get the nuances regarding the personality. Then frequently, particularly in criminal matters, I would do psychometric assessment. These are personality tests. And the personality tests become useful because they're a point in space which can confirm some of the forensic and clinical impressions. So they're not diagnostic instruments per se, but they can help to confirm the diagnosis that you're making.
What sort of time what sort of things would Oscar Pistorius be going through during the 30 days of assessment?
Well, that depends on the unit that he's involved in, but typically he'd be observed, he'd be interviewed by both psychiatrists and psychologists. I would presume that he'd be given psychometric tests. His interactions with people would be observed. His behavior under certain stressful conditions that might emerge in the hospital would also be observed. So overall, they would try to get as comprehensive picture of Oscar as possible.
If the GAD is confirmed as something that he suffers from, how would that serve him or the state at all in the case?
That I'm not sure, because that's really a legal question. You know, from a psychologist's point of view, if it emerges that they have the diagnosis, or the hospital confirms the diagnosis of GAD, then it would support the defense's argument. The real question for me, and I'm looking at this quite academically, the real question for me is whether GAD is sufficient in a personality to be able to explain the commission of this particular kind of a crime. And that's where I think there needs to be more substance. How does the diagnosis relate to the actual crime itself? And although I've not read the transcript, what little I have seen of the case, I didn't hear that explanation come through.
Do you think at best it's a mitigating factor at all if there's a sentencing, if there's a guilty verdict?
I would have seen it more as a mitigating factor, more than as a defense. From my understanding of the use of a defense, a psychological defense, the breadth is quite narrow. To be able to explain the crime in terms of a personality, it's quite a narrow defense, particularly since the ED trial. For instance, non-pathological criminal incapacity has been reduced to something quite slender. And for me, general anxiety disorder doesn't fit through that kind of gap.
Can you explain what non-pathological
criminal incapacity is? It's a condition where the personality, for whatever reason, has decompensated to the point where the person commits an act, and although they're not insane per se, in the commission of that act, they had no capacity. They didn't know what they were doing, and they weren't responsible for their actions.
Has that been a valid defense in the past, successfully?
It has been used. In fact, it was pretty widely used, probably about a decade and a half ago, maybe a little longer. And there were a number of cases that were defended in that particular way and were successful. And then in the ED matter, the defense appealed to the Supreme Court of Appeal, and the Supreme Court of Appeal did a review of the entire defense, looked at all the cases, and looked at where the decisions had been inconsistent, and reduced the defense to a very, very narrow area.
In a situation, would you have expected non-pathological criminal incapacity to have been in line with Pistorius' defense, in line with that explanation he gave of his actions being almost involuntary?
No, he didn't. You see, in the non-pathological criminal incapacity defense, the person often is not present mentally. They've either been so overwhelmed by emotion or so overwhelmed by psychological processes that they actually not present to the situation. They may be observing themselves, or they may be mentally incoherent at the time, but they perform an act. What we understand from Pistorius' defense is he was present. He very much knew what he was doing. He thought there was an intruder, according to his defense, and he took a gun and he confronted the intruder by shooting through the door. So there was an act of mental capacity there, as far as I can see. And that's very different to the descriptions that you get from people who are functioning in a way where the non-pathological criminal incapacity defense could be used.
Okay. When Pistorius...
but again, I must add, that's my opinion. That's,
when it was said in the case that he advanced towards the danger, the fight, not flight reflex.
yes.
Why do some people do that and other people advance towards danger and other people run away?
I think that's a very complex question. I think that there's a lot of reasons for that. A lot of it has to do with background, what kind of defense training you've had, whether you feel safe with the defense that you're using, in this case a gun, whether you feel that you've got to protect somebody. There's a whole lot of factors that would be running probably unconsciously through the mind of the individual to determine whether they would flee or they would confront.
Super, thank you. And that's all. We're done.
That's it?
Yeah.
Can I just make one other statement
Yes.
for you to edit into
Yes,
it?
please do.
I haven't interviewed Pistorius, and I haven't looked at the transcripts, so my opinions are very limited, and I don't want there to be any sense that I have a conclusion which is worth any more than an informed lay opinion. What I'm guarding against is that the Health Professions Council is quite tight on people giving opinions without having interviewed.
Oh, okay. I will
So
mention that
if you would
later.
just, yes.
Okay. I'm sorry, let me just write that. Will you just do some cutaways for me, please?
Okay.
Spool? Please mention thank you. Does GAD lead to violence?
Well, the general opinion is that GAD leading on to violence is quite unusual. GAD is more of a chronic condition where the person experiences worry, anxious apprehension, restlessness, fatigue, muscular tension, lack of concentration, and so on. It's a chronic, ongoing condition. Whereas the types of anxiety which we usually associate with aggression or violence are more acute. So those are the ones arising out of stress. So a person who's under a great deal of stress at work, who becomes anxious, may become aggressive. But I wouldn't have thought of GAD, certainly in my practice. I've never seen a person with a diagnosis of GAD who has also expressed aggression and or even violence.
And people who you've assessed who do commit violent acts, have any of them been diagnosed with just GAD?
No, typically in those cases you've got another, what we call comorbid condition. So you will have GAD, and then you may have another condition like a personality disorder of some kind going together. And it's usually the interaction of those two together with whatever stimuli are happening in the environment which may lead on to an aggressive act. But I've never seen a GAD in its pure form being aggressive.
You deserve to know more.
eNCA.com